Good afternoon, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the afternoon docket, and we will hear them in the order in which they appear on the docket. Let me remind all parties that each side has a total of 15 minutes, and that will apply even if there's 2 appellees or 3 appellants. You have to share that time. The appellants may reserve up to 5 minutes for a rebuttal, and so when you come to the podium after you've introduced yourself, let us know how much time you wish to reserve, and we will program the clock accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Sara Beth Schwab versus Alfred C. Schwab III.
Good morning.
Your Honors.
Excuse
Good
me.
afternoon.
Good afternoon. I already said good afternoon and
Yes.
contradicted myself.
We are on the record. My name is Catherine Everett with Davidson County Bar. I would like to reserve...
The clerk will do the clock for you.
Oh, thank you. I would like to reserve 5 minutes.
5 minutes, very good.
Your Honor, this is a very narrow issue that, to be honest, we were sort of excited to be able to bring before the court, finding no clear case law on point. Our position is, I represent Mr. Al Schwab, the appellant. Our position is that the trial court erred in agreeing with the wife that the inclusion of the reference to the statute, alimony statute, created a rebuttable presumption that would have to be overcome. We believe, as I believe the case law taught us through a number of cases, DeLuca versus Schumacher in particular, that marital dissolution agreements maintain their contractual nature. Mr. and Mrs. Schwab entered into a marital dissolution agreement that on the alimony portion, and I know this was a hotly contested divorce, the marital dissolution agreement provided for alimony in futuro with an express provision that alimony shall terminate upon the death of husband or wife, the remarriage of wife, or wife's cohabitation with someone to whom she is not related by blood, pursuant to 10 Code annotated 36-5-121F.
Counsel, I have a question about that last portion. Under your reading of this agreement, what purpose does the reference to Tennessee Code annotated 36-5-121F serve? And what does it do?
The overall, the full statute addresses things other than just the termination. It also addresses the court's continued ability to have control over the case, to make modifications if need be, and to continue to reserve its jurisdiction over the case, the alimony in the case, even if it's alimony in futuro.
The F provision that's cited, the 121F, though, does include the suspension and presumption measures with regard to cohabitation. How do we read that out of the agreement that was reached? And you're citing the contract or agreement. The agreement in this case is citing that statutory provision, and it includes the suspension language and the cohabitation presumption language.
Because it had already stated that alimony shall terminate upon death, remarriage, or cohabitation.
So are you suggesting then the reference to the statute then is just a redundancy in the agreement?
No, I think the statute is much broader than just the presumption on cohabitation. That part of the statute incorporates...
It could have cited F1 then, if it's just the retention of jurisdiction and it references F.
And by the same token, it could have recited just the alimony in futuro terminating if there's cohabitation. It didn't cite either of those. Therefore, there was nothing directly on point when that reference is made to.
What I'm struggling to see is how do we read out any part of F? If the agreement references pursuant to F, 121F, and you're saying, well, part of F includes this retention of jurisdiction, part of F also includes the cohabitation, part of it also includes marriage and notice requirements. How do we read out part 2, part 3, but just apply 1? It doesn't, the contract doesn't cite F1, it cites F. So how do we read that out?
Anytime, my understanding and my reading is that if it contradicts the plain language of the marital dissolution agreement, which is a contract, then it would not apply, and the plain language of the contract would trump.
So the plain language of the contract, I guess I'm going back to Judge Usman's question, though. So what purpose does the reference to the statute serve in the parties' agreement? I mean, it sounds like to me what you're arguing is it serves no purpose whatsoever.
I think it could serve a purpose if there needed to be a modification of the alimony award. It also serves to show that the court retains jurisdiction. Other than that, when you have already stated and agreed and negotiated the term that alimony shall, alimony would cease in the event of any of the other provisions, that's what my client was relying on.
Well, shouldn't the agreement then have read, notwithstanding the statute, these circumstances? I mean, it seems like to me that would be the better language here than if that's what the parties truly intended.
But here again, that would have been possible, but that would have also negated the case law that we have where the plain language of the contract controls.
But under the statute, doesn't it contemplate suspension of alimony instead of termination?
Under the statute,
during the cohabitation.
Yes, Your Honor.
So if we just rely upon the statute, it's undisputed that the son's girlfriend no longer resides with the mother.
That is correct.
Then there would be no grounds for suspension of alimony after the petition was filed.
That is if you are relying strictly on the statute. Mm-hmm. Strictly on the statute.
Right.
Counsel, is there any, with regard to the timeline issue, that's part of Judge Clement's question, he's asking here, is there a published decision of the Tennessee Court of Appeals that addresses the timeline of suspension in terms of filing, in terms of times of trial? I know there's a significant number of unpublished cases that I saw referenced in opposing counsel's brief. Is there a published case on that issue that addresses this matter one way or the other in terms of how you look at the timeline with regard to suspension? I know you're disagreeing with the idea of suspension, but is there a published case that addresses that question?
I saw some unpublished cases, as Your Honor did. I did not see a published case on point, which was part of the reason, to be honest, we were almost excited to be able to bring this before the court because it had not fully been addressed. Granted, that's, we were excited, not that you were.
Beware of what you ask for. We don't yet know what our decision will be. So, but your argument, if I hear it, is that it should terminate without regard to the statute. You're
that
saying
is
put
our
the statute
argument.
aside.
My opposing counsel in DeLuca versus Shoemaker did a beautiful job of representing that the contract maintains its contractual nature. And that is a large part of what we were looking at in saying, this is what he agreed to.
Isn't the pursuant to Tennessee Code annotated 36.5, 121F part of the contract, though? I mean, it's contractual language. This isn't a circumstance where you're reading in a statute that's not referenced in the contract. The contract is expressly bringing in the statute. Now, you have a disagreement in terms of what that means, what that implicates, but can we really distinguish it on that basis and say, well, the contract controls when the contract includes pursuant to the statute?
As I said, not to be overly redundant, our reading of it was it would be anything within the statute that did not contradict what was in the contract, what was in the NDA. And it is a very narrow issue, but we found it a very interesting one, especially when we could not find specific published case law that addressed it.
All right, thank you. We'll hear from you further on rebuttal. Good afternoon, Ms. Miller.
Good afternoon. Carla Miller of the Nashville Bar. It's a pleasure to appear before your honors today. I represent Ms. Sara Beth Bivens, who is here in the courtroom today. And Ms. Everett and I have been friends for a long time, and we've had a lot of fun just kind of bantering back and forth about this situation. Of course, I always think I'm right, and she always thinks she's right. But I was involved in that DeLuca v. Schumacher case, and I was very I was going to use the word vicious, but that's not the word. I was very steady in upholding that contract, and ultimately the Court of Appeals ruled in my client's favor. And so I understand why Ms. Everett cited that case. However, as Larry Cam, my opposing counsel in that case, stated, that was the wackiest MDA ever. I think that was even repeated in the opinion. And we don't really have a wacky MDA here. What we have right here is a provision that is really specific. And if you really read Mr. Schwab's argument through counsel, he's basically saying, please interpretate this contract according to the strict language, except that part I don't like. So if you're going to interpret a contract according to its strict language, you can't just omit some of the language. You have to start looking at the common sense. What did the parties intend? Ms. Everett wasn't involved in this case at the time of the divorce. I was. These things are outside the record, so I won't go into any detail, but there was more. This was a contested case. It was a hotly contested case. We did settle it in mediation. I mean, it was probably 9 hours. There was more than one draft of this agreement that went back and forth, and the one we ended with had that provision in it.
Counsel, now, you say we can't read it in the manner being suggested by opposing counsel because it reads out the language
correct.
of the statute. I wonder, though, if we read it the way you're suggesting, how are we not reading out the idea of terminating based upon cohabitation? So the language, express language, shall terminate, and it includes cohabitation. Now, under the statute, you can't terminate based upon cohabitation. You
right.
can only suspend based
right.
upon cohabitation. So if we read it the way you're suggesting, how are we not reading out the word terminate, shall terminate? And it seems like one way or the other, we're being asked to read out part of this language.
And I can definitely understand that interpretation. And basically, and Judge Martin, if I recall, addressed that. He said, well, the statute doesn't really, it says it provides for suspension, not termination. And he said, but you reference the statute as part of your agreement, even though your agreement says termination. So that's how he read it. It's like you're referencing a statute that refers to termination of the alimony obligation, suspension of the alimony obligation, although the MDA says, you're wanting termination of it. But again, what is the point of including that if not to afford, under common sense interpretation, including plain language, to afford the
Under your reading, how could you terminate based on cohabitation? Is it possible, even theoretically possible, to terminate
yes.
alimony in futuro based on cohabitation?
You mean in this case?
In any circumstance, under your reading of the provision, how could you get to alimony is terminated by an order of a court based upon cohabitation?
That part of the statute regarding cohabitation specifically references suspension.
I agree.
So I'm thinking out loud, sorry.
Yeah, but how do we, that's where I'm struggling. If we read it your way you're suggesting, I'm not sure how we're not erasing the word termination at the beginning of this agreement. Shall terminate upon the death of husband or wife, the remarriage of wife, or wife's cohabitation. So at least the beginning of it's anticipating that you could terminate based on cohabitation.
Agreed.
The statute imposes a limitation in terms of suspension. Can you even possibly have a termination based on cohabitation under the reading you're giving to this agreement?
In this case, I think so, because the statute that is being referenced was put in there for a reason. And even though, I mean, we attorneys, sometimes we lose sight of the forest for the trees. And the goal was for Mr. Schwab to have the relief of termination should, in the cohabitation respect, should Ms. Bevins, is not her last name, cohabitate with a person not related by blood. So, so the idea was that he should get relief. Now, this case, the court found that Ms. Bivens couldn't have rebutted the presumption. I think the court would have been bound to terminate the alimony obligation because that's what this says.
That's contrary to the statute. Because
I'm sorry? Well,
that's contrary to, well, what if she was cohabitating during the trial?
right.
But what if she quit cohabitating 6 months later? She
Right.
could arguably go back to court and say, I'm no longer cohabitating. The court was right to suspend it.
Right.
But now I want my alimony reinstated.
Right. And
Is she entitled to do that under the statute?
she's entitled to do that under the statute. I guess
So how do we resolve the conflict between thou shalt terminate if you cohabitate
Right.
versus thou may suspend during cohabitation?
well,
How do we resolve that conflict?
I don't know if we ever get there because the alleged cohabitation ceased prior to this petition even being filed. So, but I hear what you're saying.
Is there one way to approach this is to say what the parties' agreement actually does is it takes suspension off the table. In other words, you keep all the elements of the statute available, including the presumption and the ability to rebut it, but instead of just a mere suspension as the statute calls for, this actually calls for a termination, so it's something
Yes.
harsher under this agreement. Is that a third way?
That is what I couldn't pull out of my brain when you were asking me that question. Got a lot of stuff rolling around in there today. So yes, I feel like this was going to be a gotcha clause for Ms. Schwab because the parties negotiated it that way. So the fact that the reference to the statute maybe was inartfully drafted because the statute specifically, and the word termination was used. The word termination was used for Mr. Schwab's benefit. The statute was referenced for Ms. Bivens' benefit. And if you read that together, then you come up with exactly what Your Honor, Justice McBrayer suggested, is that it's going to terminate under this clause, even if she can't rebut the rebuttable presumption. It's terminating, not suspending, because the reference to the statute, because the word terminate is in there, and the word terminate is in the MDA. So I feel like that's how you square away that without reading it out. Again, I think that was an artfully drafted. I did not draft it, but I think that was an artfully drafted way because the goal was to give Mr. Schwab relief of termination in the event this was violated, and the goal was to give Ms. Bivens, then Ms. Schwab, the benefit if she could rebut the presumption.
Counsel, there seem to be a significant number of unpublished decisions looking at the timeline issue. Are they still cohabitating at the time of the trial? Are there any published decisions of the Tennessee Court of Appeals, Tennessee Supreme Court, that address that issue and link it to the time of trial in terms of when the calculation? And I know there's a separate issue here in terms of the cohabitation
Right.
ended before the petition was filed, is my understanding. But is there any published decision that sets forth that as the law, or are they all unpublished opinions?
Just one moment. I've been studying up on exactly what constitutes an unpublished opinion. Slip opinions are considered published, correct?
and your memorandum opinions aren't, I mean, I know that.
It's
but
not published unless it has a Southwest
Okay,
Reporter citation.
all right. Just one moment, let me.
If it barely has Westlaw or Lexus,
Right,
it's not published.
right, I understand. Okay. I was reading something from another source that,
Well, let me get to a foundational case here. though,
Sure.
while you're thinking through that.
or I'm looking at
I think Woodall may be one of the first cases where the Tennessee Court of Appeals took the view that timing of trial mattered. And part of the reasoning in Woodall was the nature of suspension versus termination.
right,
And so if that's the case, if the reason timing matters is because the payment gets suspended rather than terminated, in this case, where the action is termination and not suspension, does that rationale still hold? And it seems to me that there are two pillars that this was initially built on in these series of cases that I think are unpublished. There may be something out there that's published. I could be wrong on that. But does that mean that we're looking at something different in terms of timing, given that that pillar seems to be gone in this case, if it is, in fact, termination rather than suspension?
Well, that's an interesting point. I don't think that's really an issue here. I argued in my brief because I didn't know if opposing counsel was going to try to get him credit for any of the months, prior to the, it was something I had argued at the oral argument on the motion for summary judgment. But Mr. Schwab wasn't asking for, not in the petition. He was simply asking for termination. He wasn't asking for, well, if the court doesn't grant this, then I at least want my payments.
So there was no request here for recovery of payment?
Correct.
Okay.
Correct. Any further questions regarding those issues that I could answer? Okay. We would also assert that Ms. Bivens is entitled to an award of attorney fees if she's successful on appeal pursuant to Eberbach, TCA 365103C, and the parties' marital dissolution agreement, which does have an appropriate fee shifting provision, which I've cited in my brief.
Now, in the trial court, the trial court did not award attorney's fees.
The trial court did award at the trial level, I filed a motion for attorney fees. The motion was set for oral argument, and opposing called me. We should reach an agreement, which is documented in agreed order for a little over $12,000 in attorney fees.
The trial court did or did not order that?
The
It was pursuant to an agreed order?
Pursuant to an agreed order.
Okay,
It is
all right.
ordered and agreed,
And
and there's
obviously-
not been any.
And that's not an issue on appeal?
Apparently not.
Okay, all right, very good.
Thank you, Your Honors.
Thank you. Rebuttal?
Your Honor, for this to follow the statute only and either have partial reduction in the amount my client has paid, or to be dismissed, it puts my client in the position of having to be the hire private detectives, always be the bad cop. Why should he have to constantly monitor the comings and goings of Ms. Bivens regarding his alimony provision if he was satisfied? And that's one reason he, I'm sure, wanted that in the marital dissolution agreement, is that it would terminate. That's why the termination language is in there. He now is a pilot living in Alaska. He has, he would be going to a lot of additional expense, time,
Well,
and
this
frankly,
time he found out about the cohabitation from his son's emails. And
which-
I seriously doubt that the parties contemplated that the mother would lose her alimony if her son and his girlfriend moved in with mom. I seriously doubt that the agreement contemplated that.
But I also do not believe that a full reading and interpretation of the statute was given to the parties similarly as they were entering into this. I think he took the language as it was and had a right to do so because he believed he had a valid contract.
Counsel, do you agree that you didn't ask for any type of reduction or temporary time period, essentially, of suspension of payment in this case? It was essentially termination or bust.
We did not, for the purposes of summary judgment. If it were to go back to the trial court, we would look at the whole, based on this court's opinion, we would look at the circumstances.
Are there any of your filings seek that type of relief or remedy in this case?
I think we had said other, and any other relief that may be appropriate. At the time, my client was just, and is absolutely convinced that as he signed that marital dissolution agreement, any cohabitation would immediately cease the alimony. Any other questions?
All right, thank you,
Thank you.
Ms. Everett and Ms. Miller, for your arguments. We'll take your case under advisement.